Welcome to Dental Brain Crops. I'm your host, Chelsea Myers, and today I am joined with Trey Lawrence. He's the general counsel for the AAO. Trey, welcome to the show.
Yeah, thank you for having me on.
I'm so excited to have you. So, general counsel for the AAO, I'm sure there was a journey getting there. Talk to me a little bit about your history, and then I'll go into some of my questions I've got for you today.
Yeah, absolutely. So, as general counsel for the AAO, I head up our legal and advocacy teams. So, the legal side, that's primarily what we're going to be talking about today. So, I'll save most of that information on the advocacy side. That's all of our federal and state lobbying work that we do. That's on behalf of orthodontists and their patients specifically, of course, but really have taken even a broader view than that and really see ourselves as working on behalf of the dental profession as a whole and dental patients as a whole. So, prior to the AAO, I went to law school here in St. Louis at Washington University, graduated in 2001, and for 18 years was at a big law firm based here in St. Louis and offices in a number of other states doing litigation work. So I was in court in different areas, nothing directly related to healthcare, but a lot of those legal tools, kind of carry over once you've got the basic tool set. You can learn the subject areas pretty quickly. But so did that for 18 years, and then I've been at the AAO for almost 5 years, and have been general counsel for close to 2 years now. So really, what I like to draw on from that background pre AAO was, even though I was not in healthcare specifically, a lot of people in the healthcare law world have kind of been on the transactional side for their whole practice. So that's more of a corporate focus and, mergers and contracts and those kind of things. I think it's a little more unusual to have somebody in healthcare law that was in litigation, so is actually in court and can tell you, I've seen multiple times the way, how do juries look at information, how do judges look at issues, all of those kind of things. And that's the piece that I really try to bring to our members and the rest of the dental community through social media, is having been in court for 18 years and see how things play out in real life there.
Yeah, and it's incredibly valuable because it's, of course, what we all want to avoid, right?
Oh, absolutely.
Yeah, we're here trying to do good and do good by our patients, do good for our communities. And so staying out of court would definitely be um, the goal. But actually, I've got some really unique questions, and I'm not sure even which order to ask them in. But I loved this. You have this document that you sent to me, and I perused it. And as I was reading it, it was sparking all kinds of questions of mine and then reminding me of conversations that I've had. But you call this your legal inventory. And the suggestion is to, I'm just going to read it here, compiling legal issues that your practice most encounters or potentially could result in legal liability at some point in time. And so, will you talk to me a little bit about what prompted you to make this? And then, what are some of those heavy hitter issues that are super common in the industry?
Yeah, definitely. So, like you said, I mean, it's pretty universal. Nobody wants to get sued. Nobody wants a dental board complaint. Everybody wants to stay out of that. So, by and large, I found that practices really do want to comply with the law. They want to do what's right. I mean, they want to do what's right by their patients. They want to do what's going to keep them out of legal trouble. But just when you talk about the law, it's just this huge kind of amorphous cloud of information, and you hear things on social media and rumors from colleagues and all of that, and it just becomes, it's almost insurmountable. Where do you start? And that's really what I try to do through this legal issue inventory, is give practices a very concrete, hands-on, nuts and bolts way to start. How do we start to chip away at this? Of course, it doesn't mean you're going to in one swoop take care of every potential liability that your practice faces, but I feel like this gives practices a good place to start. And so that's just walking through that process of, hey, what are the issues that we confront? What are the problems that come up with patients? What are the things I've heard about online that can be a legal liability? Now let's list those out. Now let's find out the answers to those. Now, we'll use that as a checklist of working our way through some legal issues, and then build from there and continue that process in the future.
Mm-hmm.
So, I think some of the areas are obvious. I think the areas where the blowups with patients happen all the time, the patient contracts, the divorced mom and dad kind of scenarios, the things that really cause real world trouble in your practice, you recognize that those can have some legal implications. The kind of the silent killers that are out there that I get really worried about practices. I mean, certainly HIPAA is this omnipresent just we know it's out there. We know it has a lot of requirements, but who has all of them memorized? And then kind of within that specifically, social media and marketing is such a huge part of practices day-to-day lives now. And there's so many pitfalls there. And I think so many of those are more of the hidden ones that you don't think about, until you get a nasty letter from the dental board or a nasty letter from a government agency, that kind of thing. Those are the ones in particular that I really want to make sure that or practices are aware of.
Yeah, that makes a lot of sense. Okay, so when you say social media and HIPAA, some things that are going through my mind are like pictures of patients. Um, let's talk a little bit about that. So obviously, we use pictures in our practices to promote our practice and the work that we're doing. And as a consumer, I like seeing that. In fact, I don't think that I make many purchases without seeing several positive reviews, right? And I like seeing that in picture form. But as a patient, I may have some other ideas about what I'm comfortable with and not. So, can you talk to me a little bit about that?
Yeah, no, that is absolutely. I mean, with the social media, so heavily driving patients' choice of who they see, and then, like you said, I mean, social media is a very visual medium, so those pictures really are crucial for practices. But I think there's several layers of legal requirements that you need to make sure that you're thinking of when you do all that. So, first of all, A is make sure you have the patient's consent to use the image and making sure you're doing that in a responsible way. So, just walking up to the patient and say, "Hey, do you mind if we take your picture and use it?" And the patient says, "Oh, sure." And then you snap the picture. That one's not going to cut it under HIPAA. HIPAA is very specific that you need a written release from the patient. There's certain, the Department of HHS has some specific requirements that need to go in that release. Making sure the patient understands the scope of what the picture is going to be used for, some other things like that. So, make sure that you get a release. And then beyond that, make sure, related issue to that is, but the before and after pictures are a very popular thing to put on social media. Obviously, practices do good work, they want to show it off. There is what's perhaps a misconception that if you're only showing the teeth, you're not showing the rest of the face, or you have the rest of the face blocked out, that you don't need a release from the patient in that situation. That's a very gray area under the law, but that's one of my soapboxes that I'm really trying to raise awareness about, because I think the trend of courts is going to be to require release even for just the pictures of the teeth. There has been one state so far where a court has looked at a HIPAA case where only the teeth were shown. The practice said, we blocked the rest of the face out. It's not personally identifying. And the court said, no, the teeth are so unique to each individual that even a photo of just the teeth is personally identifying, and so that can be a HIPAA violation. So that's just one court so far, but I think with the trend of, overall trend of courts is patient protection and kind of expansion of HIPAA, I think other courts are going to go to that too. So that one in particular, I really want patient or practices to be careful about using pictures, even of just the teeth, without getting a release from the patient first.
So, what about like longer term treatment? Specifically, orthodontics is a longer term treatment. And let's say that a parent has signed a release when a child is 16 or 17, but now they've crossed over into adulthood. Do we have to have them re sign? Or does that question make sense? Can
Oh,
the child be
definitely.
not okay with the fact that their teeth are being used now that they're an adult?
Yeah, no, the child may definitely still be okay with it, but the challenge is when the child reaches the age of adulthood, then suddenly any parental consents that the parents had given for the child up to that point are no longer binding. So, yeah, there are several things, including the photo release, that if a patient turns 18 during the course of treatment, then you need to revisit, and that can be. Certainly, the photo releases, once a patient's 18, you probably, the safe practice is going to be to get a new photo release signed by the patient themselves instead of mom and dad. Another thing is the authorization for release of information. If the child was, not an adult yet when they started treatment, and mom and dad have signed all the documents, then obviously you've got authorization to talk to mom and dad about the patient's treatment. But once that patient turns 18, you need to get an authorization from the patient that says that you're allowed to discuss information about their treatment with mom and dad. So there's two or three things that when that patient reaches adulthood and mid-treatment, you need to make sure that you've got records in place that you probably didn't need when they started treatment as a child and mom and dad had signed everything.
Yeah, that makes a lot of sense. Okay, and then one more question I have on the picture front. When we go to big dental conferences or any big event, usually there's some sort of photo release that you're signing within that, those long documents. But let's say that your practice or organization is just hosting some sort of community event, and pictures are taken there. Does this same level of scrutiny apply, or if I take a picture of 300 people having donuts outside of our practice, is that okay?
Yeah. So the good news is you don't need to worry about HIPAA there because the 300 people just eating donuts, there's no information related to their
Right.
medical or treatment at that point. So you don't have the same HIPAA concerns that you do sharing patients' information. The you know the probably the fuzzier legal question is whether you need just a name, image, and likeness type of release from the 300 people eating donuts. I think most courts have said that when you get people in the background of a picture, you're not intentionally using their name, image, or likeness for promotion of your practice, like you are if you have a picture of one patient and you're featuring that one patient. So I think you're safe there on
Okay.
both of those fronts. Now, there may be, some weird wrinkle of law in a particular state, but for the most part, the general trend is you don't have the same concerns in that situation as you do of a picture featuring one patient, and especially if you identify them as a patient or otherwise talk about information related to their treatment in that.
That makes a lot of sense. Okay, so along those same lines of doing fun things as a practice or organization, I came across some of your content that I found very valuable, and it was distinguishing the difference between just having a raffle and having and holding a sweepstakes and needing to know the difference between those two things. Can you talk about that?
Yeah, definitely. So this is when I talk about the hidden pitfalls of the social media promotions. This is one, and it's a big one because if you are violating your state sweepstakes law, that can get very costly, very quick if you dinged on it. Because I'll get to the substance of the law in a minute, but on the penalty side, there's usually pretty hefty financial penalty. So let's say there's a $300 fine per violation. Well, if you're promoting your practice or promoting a contest like that online and you've got 10,000 followers on social media, then most states are going to say you just committed 10,000 violations of that law. And at $300 a pop, that gets expensive pretty quickly. So
Wow.
when do those kind of promotions fall under state sweepstakes law? There's three elements that a promotion has to have fall under sweepstakes law. And this is true nearly for every state. So first of all, there has to be an element of chance. So if you're doing some kind of promotion where every patient that does something, gets some kind of a prize, you're not doing a drawing. So that's not going to be a sweepstakes. If you have a drawing in it or some other random selection of winners, then that could be a sweepstakes. The second requirement is that there has to be the patient has to provide consideration to be entered. So that's a fancy legal term for the patient has to do something of economic value to enter. So if you have a drawing where, like, let's say you have if it's a pediatric dentist and you have a coloring contest and everybody that colors a picture of the dentist dog or whatever gets entered into a drawing. Well, that's not economic value. So that's not going to fall under sweepstakes law. But if you get entered in a drawing because you provide either because if you're a case, all new case starts get entered in a drawing, clearly there's economic value there. Or everybody who provides us a name, a family or friend member, a potential lead, then you get entered into a drawing. Courts have held that there's economic value to a lead for a business, so that could potentially fall under sweepstakes law. And then the third element is there has to be a prize of value. And in most states, the threshold is fairly low. We're talking like $40 or $50.
Oh, okay.
So if you have a drawing, patients have to do something of economic value to be entered in the drawing, and there's a prize that meets the value threshold, then that could fall under state sweepstakes law. So you want to make sure you know what your state sweepstakes law is. The easiest way to get into compliance with it, this is one of those, a lot of these legal problems don't require thousands and thousands of dollars with an attorney to fix. You can find an attorney who knows sweepstakes law. I mean, I've done this for the AAO. You contact one of those attorneys, they give you a template that meets the law in your state. Normally, the biggest thing is having written terms and conditions for your contest, and
Hmm.
then maybe a no purchase required for entry kind of option, making sure that you say the start and the end date. I mean, basic stuff like that. But you can set up a template, work with a lawyer one time, and then from then on, every time you do one of those contests, you just fill in the blanks on the template, and it's a real easy process. But you just need to make sure that that that's potentially an issue and work with an attorney to get all that set up.
Yeah, that makes sense. So it sounds like we can do it. Just do it in the right way. And okay, yeah,
Right.
that keeps it
Yep.
fun.
Yes.
Great. Okay, so talk to me a little bit about some. We touched on social media, but talk to me about some major marketing do's and don'ts. What can we say? What can we not? What's important to know there as we're starting out, particularly if we just decide randomly, okay, I want to start an Instagram account for my practice and I'm handling it myself. What do I need to know right out of the gate?
Yeah. So one of the big things that you have to recognize is that the requirements on what dental practices can say in their marketing is a little different. It's a little more restrictive than just businesses in general. And that's because most state dental boards rules specifically have a rule saying that dental practices are held to a higher standard of truthfulness than other businesses. And that's because the public places a higher level of trust in a dentist or an orthodontist, or other dental specialists because of their education and those kind of things. So that's the first thing, is recognize that even though, any business advertising, obviously you can't say things that are untruthful, but dental boards in particular are going to hold, dental practices to an even higher standard of truthfulness. So you need to make sure that anything that you say in an advertisement can be factually supported, that you got some kind of evidence to support what you say. So that then applies to things like comparative claims are a big challenge. So, businesses all the time will say, oh, we're the best car dealer in town, or we're the best whatever in town. When it comes to a dental practice with that higher level of factual support required for what you say, how do you demonstrate that you're the best, dental practice in your town? Or how do you demonstrate that your doctor is the most skilled or the most knowledge? Those kind of comparative claims are very problematic. Some states' dental boards actually say you can't do them, but then others have still taken action on those because of the challenge with demonstrating those. And then that also goes for, treatment methods or materials. Our We use Invisalign, and it's the best aligner out on the market. Well, again, how are you going to demonstrate that? So those kind of things are very challenging, and you need to make sure, now if it's something like our dentist or our orthodontist has the most experience of anybody in town. Well, that may be something you can factually support, because you can say, oh yeah, he's been in practice or she's been in practice since, longer than any other orthodontist or dentist in town. So you would have the support there. So that's a big category, are those comparative claims. There are other kind of wrinkles under states' dental practice acts and their regulations. One, don't say that you have pain-free dentistry or pain-free treatment. That's specified in many states. Advertising as a specialist can be a challenge. Most states have specific requirements about the education in particular that you have to have received. If you want to advertise yourself as a dental specialist, it has to be in one of the fields of specialty that are recognized by the ADA, and you have to have gone to a CODA accredited educational program in that specialty to advertise in those fields. So those are the kind of things that are a little unique to dental practices and what they can or can't say. And those apply, when we say advertising, it doesn't just mean like print ads or that kind of thing. Social media definitely falls under your state dental board's advertising restrictions.
Mm-hmm. Yeah, that makes a lot of sense. Okay, so speaking about talking to patients online and communicating with people in that format, let's talk a little bit about negative reviews. Um, I see I'm sure you do too. You see more of it than I do, but I see things all across the board, from really almost robotic, same response every time to a negative review with some companies, and then all the way up to getting into what feels like a bit of a battle online with patients. So, what is the recommendation?
Yeah, I know this is where the lawyers and the marketing people kind of butt heads here because I know the robotic type of responses, like you mentioned, are not preferred from a marketing perspective, but there are definitely some legal reasons why practices use that. So the challenge with responding to patient reviews online, whether good or bad, the risk is always going to be committing a HIPAA violation. And I think the piece that a lot of practices don't realize is how quickly you can get into having committed a HIPAA violation. Like that threshold for what constitutes protected health information is so low, even just acknowledging that the patient was a patient at your practice is disclosing protected health information and can get into HIPAA violation territory. And so that's why those robotic type of responses many times have been really carefully calculated to not reveal anything factual about the patient. So like from the AAO's perspectives, the ones that I always recommend to practices is if you get a negative review online, our two sentences that we always use are, it appears there's been a misunderstanding. Please contact our office to set up a time to discuss. So I'm not disclosing anything factual about the patient. I'm not even acknowledging that they were a patient at the practice. I'm just asking them to come in to talk to us. And the other thing I'm doing, this is not HIPAA. This is just from my court background, is you're not admitting liability. That's another thing I think practices don't realize is, so admissions of liability are a huge deal if you end up at trial or you end up in a dental board proceeding, because an admission, if you've admitted liability, then that really lowers the evidentiary burden for the plaintiff in a malpractice case or the dental board in a dental board complaint. So plaintiffs' attorneys in particular get really crafty with twisting things that people say, and they weren't really admitting liability, but they will try to misconstrue it as an admission of liability. So I'm sorry, or we're sorry this has happened. Those are the kind of things that people, when they say them, they're not meaning I'm sorry I messed up your case. They're just saying I'm sorry you have, a problem. It's just decent, basic human decency. But plaintiffs' lawyers will twist that as an admission of liability. So that's why it appears there's been a misunderstanding. Please contact our office to set up a time to discuss on the bad review side. And then on the good review side, I think that one's almost more of a risk in some ways, because if a patient just gets online and just writes this glowing review about you and your practice, you probably loved them as a patient. You want to get on and say, oh God, we loved you. You were an awesome patient, or you had such a great result because you complied with all your treatment instructions or something like that. But all of that, again, is protected health information that technically could constitute a HIPAA violation. So again, kind of a stock response on the positive side, something like, we love hearing great reviews like that, or thanks so much for the positive comments, or things like that, that acknowledge the positive review, but they don't even acknowledge that the
Mm-hmm.
person was a patient, will keep you out of the HIPAA violation. And so then just to wrap all this up, just if anybody says, well, does all that stuff really matter? I watching the legal news, there are cases that come out all the time where HHS is fining some practice, $25,000 or $50,000 for committing a HIPAA violation in their responses to online reviews. So this is definitely one you need to be careful about, because 99% of the time it may not ding you, but the one time it does, it can be really costly.
Mm-hmm. That makes a lot of sense. So you had mentioned something about saying I'm sorry, or certain languaging that we use just kind of casually that transfers to our professional environments. So, and we were talking specifically about online reviews, but would you make the same recommendation if a patient is talking to you in person, about being strategic about how you answer something, particularly if you're not liable for what they're accusing you of or what their issue is?
Yeah, as the lawyer, I definitely say that's something you need to have in the back of your mind. I mean, maybe not, the second new patient walks in the door, you probably don't have to be thinking at that point about, okay, what do I need to do to not say something that's going to be a problem in the lawsuit eventually. But, if you have a problem situation with the patient, if the patient is thrown out, I ought to talk to a lawyer about this, or those are the kind of red flags that maybe you do need to take
Mm-hmm.
the caution level up a notch at that point. And so you do need to start thinking through the lens of whatever I say in this case, how could this potentially be used, at trial if this does end up as a malpractice case? And so those things like being aware of not saying things that could be misconstrued as an admission of liability, or understanding, just understanding that if this is headed to trial, the patient's going to take everything back to their lawyer that you just said, and make sure that somebody couldn't misinterpret it. The one benefit of that in-person conversation that is a little different than the online that we just talked about. If you post something online, it's there in writing. It's up for the world to see. There's no disputing it. It's a little easier if you're talking about a comment during conversation in person with the patient. There's other evidence that can come into that. You can say, well, no, I didn't mean it that way because of the context of the
Mhm.
conversation, or the patient said this before that. So your lawyer can help you out a little bit there. When it's in writing, and especially when it's up online for the world to see, there's not much the lawyer can do to rescue you at that point, and that's why you've got to be even more careful there. But yeah, I would say that the second those red flags go up with the patient about this might be headed toward, a legal or dental board type of situation, then you probably do need to start thinking through a little different lens as far as what you say to the patient.
Yeah, no, that makes so much sense. I appreciate you going through that. And then, not to freak people out who might not be currently freaked out about this, but like if you're having that in person conversation, there have been some concerns about people using their cell phone as a recording device for that conversation. And so that's where I was coming from when I was asking, should we have maybe an arsenal of responses that we're prepared with while we're deciding what's happened with this patient and how we want to proceed? And it sounds like the answer is yes. We should know how
Yeah.
we want to respond.
No, and that's a good question about the cell phone recording too, because that can add another wrinkle into it. Now, part of that depends on what state you're in, because some states require only, if you're going to record a conversation, some states only require the consent of one participant in the conversation. So that would be the patient, meaning they can hit, as long as they're the one doing it, they can hit record on their phone and they're legal under their state, and that could potentially come in as evidence. There are other states that require the consent of both participants of the conversation. So if a patient recorded you without your knowledge and didn't get your consent to record it first, then that wouldn't be admissible at trial because it was illegally recorded in your state. So it's not a bad idea to get on. That's one of those, unlike some legal questions, that one's really easy to find on Google. Might be helpful just to get on Google and quickly find out whether your state is a one person consent or a two-person consent as far as recording conversations.
Yeah. Yeah. So just to put a bow on that one, it's if somebody comes to you and they're obviously upset, decide in advance what is your immediate response and what is your invitation to follow up with a more in-depth conversation where you can research the situation and decide how you want to proceed with that.
Yeah, definitely, definitely.
Great. What else have I not asked you? I'm referring to this document again, but we've had such a good conversation. What else have I not asked you though that would be really important for people to have on their mind when they're doing their inventory?
Yeah. So this is kind of related to what we talked about with sweepstakes earlier, but this is another one when we talk about the online promotion and the things that people just don't even think about posing an issue is, so any kind of referral incentives that you give patients. I think everybody knows fee splitting is illegal in every state, but when people think about fee splitting, they think about some kind of a deal, that an orthodontist works out with a GP where they pay them a certain percentage treatment fees for every referral, that kind of thing. I think what people don't always think about is the fact that things that you do with you can fee split with the patient, first of all. It doesn't have to be another provider to fall under fee splitting. And that some of those kind of incentives and referrals that practices use can potentially fall under fee splitting. So the two elements there are if it's on a per patient basis and it meets the dollar threshold under your state's dental boards, then it could be fee splitting. So let's say you have a program where every new patient, every new case start that we get referred to us, the patient that referred them gets $100 Amazon gift card. That could be fee splitting because it's for every referral and it would probably be over the dollar threshold in every state.
Mm-hmm.
So that is certainly one that I don't think practices think about that they need to. And then one other thing that's related to that too, um, when practices are doing a lot of things these days to kind of prompt good reviews or good testimonials from their patients. So maybe, hey, go write a good review for us online. You get entered into a drawing, or every patient that writes a good review for us, or, on Google, or they provide us with the testimonial we can use, we'll give them white free whitening kit or something like that. The FTC has really been cracking down over the last few years, the Federal Trade Commission, on paid endorsements, and that definitely includes dental practices. So it's not that you can't do those kind of things, but if you are offering patients some kind of an incentive to write those good reviews or to provide those testimonials, then any advertising that you use that in, you need to have a disclaimer that says that patients were received an incentive or for providing that review or that endorsement. So it doesn't have to, it doesn't have to be a big banner at the top of the page, the little fine print down at the bottom of your web page or whatever is fine. But that's another one in particular. The FTC has really been looking at these and has dinged several dental practices and other medical practices lately for giving out those kind of incentives for the Google reviews and not disclosing that in the advertising that they use them in.
Yeah, I've been seeing those more and more. Like this review was a part of a promotion or gathered in, in response to an incentive. I've seen those more and more. I had an experience not too long ago, non-dental. Tulsa's pretty small, so I just want to clarify non-dental, and to not disparage anybody. It's really irrelevant where I was, but I was leaving an office, and they said, "Hey, if you'll give us a 5-star review before you leave, then we'll give you a Starbucks gift card." And I got to tell you, Trey, up until that point, it was actually a fantastic experience. But what I didn't like was that I was told exactly which review. It wasn't if you give us a review, it was if you give us a 5-star review. And I was like, well, that's a little interesting. And she said, and so I clarified with her. I said, can you tell me that again? And she said, yeah, if you give us a 5-star review, and then actually I need you to flip your phone around and show me that you gave us a 5-star, and then we'll give you like, okay. So I think like even just the human element of it, it may work. I'm sure it would work for a lot of people. But just when you're talking about your reputation and actually serving the community that you're in, and checking all of those boxes, whether it's a legal thing or not, I think there's a lot to be considered about how you're going about promoting your business, because ultimately that's what we want, right? We want to share that we do good work and that people are pleased with their results, and we want more people like you to come get those good, pleasing results from us. And so
Yeah.
that's an honorable thing, but going about it in a way that feels good to everybody is really important to consider.
Oh, definitely. Yeah, I think completely separate from the legal considerations, it's the, authenticity and marketing, especially authenticity is always the buzzword with social media. And if patients get the impression that all of your glowing comments have all been coerced or whatever, then it's going to lose that authenticity and lose the effectiveness. And the other benefit too, like in contrast to what you said about leave us a 5-star review and we'll give you some incentive. If you just said to patients, just leave us a review, you don't dictate, leave us a good review or anything like that, then you probably don't fall under the FTC's concerns because you're not endorsing patients for a good review. You're just asking them for a review period. So that may fall outside of that. So even aside from the authenticity and the kind of the purely marketing concerns we just talked about, I think there might be some legal reasons just to ask for a review and not ask for a positive or a 5-star review.
Yeah, that makes a lot of sense. Totally. We've got somebody asking a question. I've been in some practices that have a security camera in every operatory. Is that something that you see happening more, and do you recommend it?
I think that varies widely from practice to practice. Obviously, there's a cost associated with that, and then the concerns are what are the concerns that prompted that. But at the same time, with security situations, I can totally understand why practices would do that. So, as far as the legality of that, you're going to want to check what the law is in your state because different states have different laws and disclosing to people. This kind of goes back to what we were talking about with the recording of conversations. There are varying levels that you need to let somebody know that they're being recorded in any way, whether that's security footage or otherwise. And so, if you want to do that, just talk with an attorney in your state, find out what the law is in your state. It may, it may be something that you have to notify every patient individually. It may just require that you have a sign up in your practice, maybe a sign in the waiting room, just saying that security cameras are in use. But I think in many states, there would be some requirements that patients need to be notified in some way that they're doing that. Now, the other wrinkle to all of that, this is the wonderful world of HIPAA, that cloud that never seems to go away, is because those security cameras are picking up patients' PHI, information about their treatment because you're literally videoing the treatment underway, then if you like say your sister has a restaurant and they put up security cameras in their restaurant and she says, oh, we had a great experience with it, so you hire the same company for them. Obviously that company's not thinking about HIPAA concerns
Mhm.
when they install the cameras in the restaurant. They need to think about them. You need to make sure that the company that you're working with does everything in a HIPAA compliant way, and that's going to require encryption for any lines of transmission where that, like if that footage goes back to a central server for the company, you need to make sure that that's an encrypted transmission. You're going to need to make sure that the company signs a business associate agreement as far as if they store the footage. So there's some things like that. So if you're going to do something like that with the cameras in your practice, make sure that the company providing those cameras is knows what the HIPAA requirements are and is complying with them, and you get a business associate agreement and all those kind of things.
Wow, such good thoughts and ones I definitely wouldn't have thought of. And so it's always why I love having people like you in our corner. So what else? What else do you have for me today?
This is the point in the conversation where I feel like we've scared everybody to death as it is, and so as the lawyer, some of this makes for a really interesting cocktail party conversation, but at a point you learn to just shut up because otherwise
Yeah.
people say, yeah, that was really useful. I don't ever want to hang out with that guy again though, because I had nightmares
No, I
after I
totally
talked.
get it. Yeah, I get the same types of responses. I'm like, I can coach you on that. Like, no, I don't want to be coached right now.
Yeah.
But yeah, okay. So let's say somebody does have other questions. First of all, you have a really fantastic Instagram account that I follow. Tell me, is it the Ortho Attorney?
Yeah, it's the Orth Attorney.
The
That throw
Orth Attorney.
Orth Attorney. I was trying to make it the same number of syllables as orthodontist. Apparently, I found out since then Ortho Attorney is much less confusing. But yeah, it is at the Orth Attorney, all one word. And so yeah, that really what that is we have, like in my role as with the AAO, we share all the kind of legal information that we're talking about today. We share out with members, and I recognized really quickly that there's kind of nobody. Wanted to make sure the rest of the dental community could benefit from that information too, and also even our own AAO members, is every association in the world, the ADA, every other association, you struggle with what's the most effective way to communicate with our members. And the emails and the newsletters and the things that worked 10 or 20 years ago, people are social media driven, and 7-second reels and TikTok videos and those kind of things. So the Orth Attorney was a way for AO members to get that information to them in a communication format that's maybe a little more relevant for many of them, and then also an opportunity for us to be a benefit to the dental community as a whole and get the information to those outside of the orthodontic world too.
Yeah. Well, I really enjoy it. You got to keep doing it. And so the Orth Attorney.
Yep.
And any other places you want to direct people to?
Certainly, if you're an AO member, the AO member website has a lot of legal resources. So things like patient contracts, informed consents for supplemental informed consents for specific procedures, releases, and for liability, and all of those kind of forms, and a lot of blog articles and news type of articles about the things we're talking about. If you're not an orthodontist, but you're an ADA member, they've got very similar resources too. So I'm always surprised at the AAO members that call in and don't even realize that we have all of that. So I would say anybody in the dental community, whatever associations you're a part of, make sure that you're taking full advantage of the legal resources that they already have up on their websites for their members.
Very good. Very good. Well, thank you, Trey. This was a lot of fun. I learned a lot, and I'm really excited about this conversation.
Okay, good. No, I'm glad. And again, to everybody who's listening, I hope that if you have nightmares because there are 20 things that you never even thought of were legal risks, then please go on my Instagram, get my legal issue inventory, and start working through those things. I really don't want people losing sleep over these legal issues. And so hopefully that wasn't the net result of this conversation.
No, I felt like it was enriching, but that is why we do these things on Friday, so we don't impact their work week too much.
Perfect.
All right. Well, have a good day, Trey.
Okay, thank you.
Hmm.